So I would love for the creativity of this conversation to come up with some context, because I do want to support this. I absolutely want to support a 9 p.m. to 9 a.m. Restriction on certain activities that block public way, that rise above the noise level, the decibel level, or and you can pick the decibel level. It could be, for me, if it's 3 a.m., I don't need the 7. I think 70 is too high for 3 a.m. I would put it even lower. But that do these things, the time and the noise level, I would want those restrictions to be put in. So that's what I think the time we have. What we don't have is the noise level. If you can put that in there, I would support this, because I believe at that point it's causing harm. So
I think that is a question for you, corporate counsel, to answer.
Well, I not to disagree. But we are.
Look if you do.
Yeah. We are. I think totally happy to review any language or dig into any language. I don't think that we can just because we work with language a lot start offering changes to the policy. This body certainly can, and we're happy to sort of work with you and engage in that conversation. And I think that, so, I mean, I guess that's all I can really say right now, which is we are always very willing to look at proposed language, whether it's right here in the working session or any other context. And I see what you're talking about, Councillor Edwards.
Would it really make sense then? This would be my language proposal or my suggestion. I know, Councillor Roy, I have to leave. I will send it to you in an email ultimately. But if you were to flip the ordinance to simply say there shall be no, and then all the verbs that you have, protesting, picketing, such and such, over 50 decibels between the hours of 9 p.m. and 9 a.m. or over 20 decibels, whatever the decibel number is, and just flip it so that there's an actual quiet hour time for that activity. My thoughts might be to do to do that. Again, because I do think you may run into a constitutional challenge of someone who just does a silent protest outside my house because they can't stand the traffic or whatever. A silent protest that doesn't block traffic, that doesn't wake me up or cause harm to children or elderly in my neighborhood, but happens to be at 8:30. I wonder.
Do you want me to address this, Adam?
Or I think there is one. Rob, please. I think there's a relevant comment in Frisbee here. But
yes. And Councillor, just to point out what you said, and this is speaking specifically to the silent protest, noise levels and such. In the decision in the Frisbee v. Schultz case, the significant government interest that was recognized was the interest that people have in privacy, and protection within their homes. And one of the things they focused on was an individual who had targeted protesting outside of their home, regardless of the noise level, regardless of the amount of people, that a silent protest even could have the effect of having a person held captive in their home, feeling as if they can't leave their home, feeling as if they are being intimidated in their home, which can happen without noise. And the court specifically recognized that those sorts of protests do infringe on that significant government interest. So in terms of the constitutional issues that we may run into, the Frisbee v. Schultz case has addressed those types of constitutional issues and the types of harm that can be created by any type of targeted protest at a single residence.
And the government interest is the protection of privacy within the home.
Correct.
Mm-hmm. And so I think that the difference would be then, and might be, I know we're talking, it's not about the mayor of Boston or any of us as elected officials, but there might be a certain level, I wonder, the case law that says about my expectation of privacy within my home and residential as an elected official, where my address is put out every time, I'm sworn in and so on and so forth. And the expectations of my neighbors are different. I don't know. This doesn't make a distinction between the two. It's treating me and Michelle and Kendra and Ricardo like our, neighbors who are anonymous, non-elected, and not public servants, and not people who would be coming to them to redress necessarily their constitutional rights. So that there is no distinction might also be a problem, because I don't know of too many non-political figures who are getting targeted residential protests. So I'm inclined to lean in and support this despite these concerns. I want to be very clear about that. I also still think that there might be some, and I can send in some suggested scrivening words that might help to narrowly tailor it. But I do think that there's going to be a concern when it's a silent protest outside someone's house. And it would be on, the person who's being protested to prove that it would intimidate them, violate their privacy. I understand the burden of proof would be on them or on the government who tried to enforce it. So, but thank you so much for this. I appreciate it. And I think that that's it for my questions. And I will send to all my colleagues, I will send my suggestions to everybody at the same time.
Thank you, Councilor Edwards. Councilor Lara, I'm going to skip through my questions.